Good afternoon, and thank you all for coming. I can say it gives me great professional and personal pleasure to be able to present my longtime friend, Joan Biskupic, to talk about her new book, Chief: The Life and Turbulent Times of Chief Justice John Roberts. Joan has written about now 4 justices, earlier having done biographies of Sandra Day O'Connor, as well as books on Antonin Scalia and Sonia Sotomayor. So if you look at the span of who's been on the court in recent years, she has kind of covered the waterfront. Joan has written about Supreme Court for better than a couple of decades, for the Washington Post, USA Today, and now is a commentator on the court on CNN. Also, while she did this, she got a law degree at Georgetown at night, mind you, at night. A couple of introductory comments. As I expect that most of you know, John Roberts became the Chief Justice in 2005, being confirmed to that position shortly after the death of Chief Justice William Rehnquist, for whom Roberts had clerked after he graduated from Harvard Law School. The two were sufficiently close that Roberts was a pallbearer at Rehnquist's funeral. After his clerkship, Roberts worked in the Reagan administration in various positions, the Justice Department, White House. He then became a highly successful appellate lawyer, winning many cases in the United States Supreme Court, many of them on behalf of, although not all, but many of them on behalf of large corporations. Shortly after George W. Bush, the second Bush president, became the president, he nominated, and Roberts was eventually confirmed to the D.C. Circuit Court of Appeals, which is often considered the second most important court in the country. In addition to Roberts, among other members of the court right now, Ruth Bader Ginsburg, Clarence Thomas, and Brett Kavanaugh all also served on the D.C. Circuit. Roberts was confirmed 78-22. A much wider margin than some of the other recent appointees. In Roberts' confirmation hearings, he presented himself that the judge should be engaged in what he called judicial modesty. He basically likened the role of a Supreme Court justice to an umpire calling balls and strikes. Considering that the Supreme Court considers rather monumental issues like voting rights, abortion, school desegregation, the role of money in finance, and many other important things, some commentators were openly skeptical of the notion that Supreme Court justices had such a limited role. Perhaps the most trenchant comment on this was offered by Stanford University law professor Pamela Karlan, who said, Supreme Court justices just don't call balls and strikes, they define the strike zone. In any case, Joan's book on Chief Justice Roberts is the product of a prodigious amount of research, some of which she did while she was a scholar in residence here a couple of years ago. She interviewed the Chief Justice himself 8 times, as well as interviews with many of the other justices on the court. The book has drawn rave reviews so far. I just want to quote one of them, which comes from the distinguished constitutional scholar Jeffrey Stone, a professor at the University of Chicago Law School, who himself clerked on the Supreme Court. He called the book extraordinarily insightful and said it was essential reading for anyone who truly wants to understand this pivotal moment in United States Supreme Court history. One of the most striking things about Joan's book is the sense that she presents early in the book is that from a very early age, John Roberts was aiming high. Joan, would you tell us a little bit about Roberts' upbringing and how you see that carrying through to where he is now?
Sure. Thanks, first of all, for having me here. And I love it that Henry referred to the fact that I was a product of night school at Georgetown. It's one of my proudest things. I was able to do it working full time. But also that I was here for a full year as a visiting professor and doing much research. And it's so great to see so many of my old pals among the students and the faculty. So thanks for coming out today. When you ask about his childhood and upbringing, I do want to quote from a letter that you and I both know well. when I began my research on John Roberts, I traveled to his hometown in northern Indiana. He grew up in a place called Long Beach, right on Lake Michigan. And I went to the very elite prep school that he had attended called La Lumiere. And there, under glass at the school, was this letter. And it said, it was written by John Roberts when he was 13 years old. On December 22nd, 1968, and it was written to the school headmaster, and he was applying to this school. And I think you'll see some of the themes that emerged in the young John Roberts at age 13 have carried him throughout. This is a letter of application. Dear Mr. Moore, the main reason I would like to attend La Lumiere School is to get a better education. I've always wanted to stay ahead of the crowd, and I feel that the competition at La Lumiere will force me to work as hard as I can. At an ordinary high school, it would probably be easy to stay ahead. I realize that going to La Lumiere will be a lot of study and hard work, but I feel confident that these labors will pay off in large amounts when it comes time to apply for admission to college. And then he closes, I'm sure that by attending and doing my best at La Lumiere, I will assure myself a fine future. I won't be content to get a good job by getting a good education. I want to get the best job by getting the best education. Sincerely yours, John Roberts, Jr. And you'll see, if you get a copy of the book, that I reproduce it because the school was so proud of it, and I thought it was such a revealing letter. So he gets in, of course, and not only does he get in, he ends up being first in his class. As Ken Starr told me when he was talking about first meeting John Roberts in 1981, John Roberts was Mr. Everything at that school. And he was. He belonged to all manner of extracurriculars, took extra classes in Latin and Greek, calculus, and he becomes the first La Lumiere student to go to Harvard. He does Harvard undergrad in 3 years and then ends up in law school. But just to stay back in Long Beach, Michigan for a few minutes, he's one of 4 children, the only boy. His father is a steel company executive, which is what brought them to northern Indiana. He was at a Bethlehem steel plant. So he grew up in a very comfortable life with superior education, and but eager to go on to a bigger, better school.
And a star student then at Harvard, and then at Harvard Law School.
Yes.
Clerks for first a prestigious judge in New York, Henry Friendly, and then goes on to the Supreme Court with William Rehnquist.
That's right.
And he arrives in D.C. at about the time that Ronald Reagan becomes the president.
Right.
And he is a great enthusiast about Ronald Reagan, and he writes a letter to Judge Friendly saying that it's so exciting to be in D.C. at a time when so many things that were taken for granted, not stated explicitly, but a number of things taken for granted are now being subject to question. So I think it would be useful if you would talk a little bit about what Roberts did while he was working in the Reagan administration and how perhaps it foreshadowed some of the things that he would do when he became a judge.
That's right. First, imagine him at the U.S. Supreme Court. He's been a law clerk, first to Judge Henry Friendly in New York, as Henry just said, and then he's worked for Associate Justice, then Associate Justice William Rehnquist, and he's watching Ronald Reagan's January 1981 inaugural speech, and he says, I felt the call. He had resisted the liberalism of Harvard, and lucky him, conservatism was right in ascendance at the time. So he feels the call of the Reagan administration. He's interviewed and hired by Ken Starr to work in first the Justice Department under Attorney General William French Smith, and then in the White House counsel's office under Fred Fielding. And he sometimes portrays himself as just a loyal lieutenant or somebody just following the agenda of the administration, but he embraced it. He loved it. He was happy to be with like-minded conservatives, working on voting rights, working on a lot of the culture wars issues, and worked super long hours and met many men who became close friends of his for life.
And at that point, he was not married and just working and playing tennis, playing golf occasionally, but working a lot of hours.
Yes, he didn't get married until his early 40s, and he was pretty much devoted to work at that time, and as I said, enjoyed it, thrived on it.
So one of the issues that is came up in letters that he'd written, memos that he had written when he was up for confirmation, were a lot of material related to race relations. Right. He expresses skepticism about some of the things that the court had done as it relates both to schools and to voting. Please talk about that a bit.
Sure. Right when he shows up, within months, in late 1981, he's part of the Reagan administration's effort to rein in the 1965 Voting Rights Act in two key provisions, Section 2 and Section 5, that cover both direct discrimination and another one involving preclearance, which becomes an issue for him when he's later as Chief Justice. And by that I mean the provision of the Voting Rights Act that had required states and other jurisdictions with a history of discrimination to have their any voting change cleared first by the Justice Department. So there's a reauthorization of that provision going on in 1981-82, and then also a strengthening of another section of the law known as Section 2 that Congress is pushing through, trying to add more teeth to the direct discrimination area of the law. And he is very robust in his approach with William French Smith, sending him many memos, trying to sort of embolden him, give him strong talking points when he's dealing with Congress about the need to remove federal involvement in some of these areas, leave these kinds of issues to the states, and he actually has a keen eye for how the media are operating at this point. He's saying, remember our message is that we're for voting rights. And he unspools a lot of this that, as Henry says, comes back then in 2005 when Democratic senators unearth these memos and say, what exactly were you talking about here? But he made very clear that he, both in the voting rights area and the school integration area, that he found, even as a young man, in his mid-20s at this point, racial remedies to do, as he said, more harm than good.
Right, but putting it in military terms, he wasn't just acting like a mere corporal. He was acting like a captain or a colonel advising the general, right?
He had a very confident writing style in those years. He's born in January of 1955, and here we are in just 1981. So he's just 25, 26, and he's confident. He has a very assertive writing style. His colleagues from that era said that his first draft was as good as anybody's second draft, and he used those skills to push the agenda that the Reagan team was part of.
Listen up, law students, to the importance of clear writing. During that period, there were a couple of other things, though, where he's also showing his hand on abortion and also expressing concern, very prescient in a way that, oh my God, some of these memos might be public someday under the Presidential Records Act, which was enacted, I think, just 2 years before he got to D.C.
Yes, it was a remnant of the Watergate era, just the idea of what can be seen of presidential papers. And John Roberts is someone who so many of his associates and friends have said he always sees, he can see out many steps. He sees things very clearly. He knows what's going to come next. And here he is, as I said, by this time when he's writing about the Presidential Records Act, maybe 27, 28 tops. He's not, he's still a very young man. And he's concerned that a provision of law that allows materials from the White House and executive branch to be made public after, I think it's after 12 years after a president leaves office, that this will be available to the public, to members of Congress, to people like me. And he's saying, people are speaking candidly in these memos, and some of the authors, and he says I think one of his lines is at one point, some of the authors, some of whom might be working with us right now, these materials will be available. And he tries in vain to get his bosses to try to limit the scope of the Presidential Records Act, and it doesn't go anywhere. But seeing those memos, it makes you realize how far he was looking ahead. And sure enough, in 2005, those memos are brought out, and Democratic senators try to use them against him, but sure. And he did an excellent. He explained his way out of all those.
Yeah, he was a brilliant He was a brilliant, for any of you who watched the hearings, he was quite a brilliant witness.
Well, do you know that for subsequent nominees to the Supreme Court, Democrat or Republican, their handlers always say, watch John Roberts do what John Roberts did.
What was he saying in those early years about reproductive rights?
That was another issue where he, well, both for the Ronald Reagan administration and then when he joins the George H.W. Bush administration, he doesn't like Roe v. Wade. He doesn't like, the 1973 landmark that made abortion legal nationwide to try to curtail it. He's in favor of restrictions. The Reagan administration and then the George H.W. administration is urging an overturning of Roe and certainly an emboldening of states to put restrictions on the right to abortion.
Right. So I want to go back to something you mentioned a moment ago, voting rights. Mm-hmm. So I assume most of the people in this room know it is a matter of historical fact that for, I'm just going to arbitrarily use the term 90 years from the end of Reconstruction until 1965 when the Voting Rights Act was passed, millions of African Americans in this country were denied the right to vote. People died in the South and as part of voter registration campaigns. The Voting Rights Act that was passed in the Johnson administration, then extended by Congress a few times, and then comes the challenge to Voting Rights Act in a case out of Alabama in an area that had been unfriendly, I guess would be the most amicable way I could put it, to African American voters. And there's this very hotly contested case, and it was a very amazing oral argument where during the course of the oral argument, Justice Scalia, who you've written about before, one of Roberts' allies on the court, at least on this issue, said that extending the Voting Rights Act would merely be a perpetuation of, quote, racial entitlement. And that case was resolved 5-4. Talk a little bit about Shelby County, because I think in a way it's one of the most important decisions of the Roberts tenure. And
written by him. One thing you'll notice in my book, I often point out that the chief will many times hand Sam Alito the majority opinion in these 5-4 cases. He's the one who has to, pro or con. I'm sure Sam Alito likes writing a lot of these majority opinions, but they're the ones that get a lot of criticism, and the chief has him do it. But on issues of race, the chief will often keep them himself, and in Shelby County, he certainly did. And this was a 2013 case that followed on a 2009 important case where John Roberts had planted the seeds for that development. But just to sort of connect his time in the Reagan years to this ruling, part of it involved the reauthorization of this preclearance provision I was mentioning earlier, and that was what was going on in 1982 when he was with the Reagan administration. That whole idea of how long should Congress authorize it for? And Congress in 1982 authorized it for 25 years, and here it was up again. Congress had reauthorized it then in 2005, 2006.
After extensive hearing and thousands of pages of testimony.
Right. To say there still is a need out there to have certain election law changes run by the federal government, by either the Justice Department or a special district court, to make sure that these states are not trying to restrict the right to vote, restrict the franchise. So it's one that's been documented over and over in terms of the need. But this is where Chief Justice John Roberts said famously, things have changed in the South. And during oral arguments, he was not as incendiary as Justice Scalia was, but he tried to make the point that the southern jurisdictions, northern jurisdictions, you can't differentiate. He really was critical of then Solicitor General Don Verrilli during those arguments, saying, you don't realize that Massachusetts probably has as many voting rights problems as some places in the South. And his feeling, as he expressed then in his opinion, is that this was an unfair formula and that it singled out places that, really had gotten over the sorts of discrimination that this law was intended to solve. And this was the case. It was 5-4, as Henry said, 4 liberals. Justice Ginsburg writes for the dissent. And this was the case where her dissent goes viral and the notorious RBG meme is created in this particular case. And he's, because he's so certain that this is not needed, and he uses a rationale that hadn't, I think it was either one time, twice even used in the history of the court, this equal sovereignty rationale that had not been used in this kind of context ever before. And Justice Ginsburg really, and the liberals call him on that rationale, but then also talk about how she uses the metaphor that if you've got this preclearance kind of protection, which she likens to an umbrella, if you say, well, there's no problem, we're not getting wet here, and then you say, well, fold up your umbrella, everything will be fine. No, everything will not be fine when you fold up the umbrella. And sure enough, in 2013, right after the Supreme Court ruled in Shelby County versus Holder, Texas, North Carolina, and other states immediately began putting into effect new voting restrictions.
Right. I also think that at the time, as I recall, one of the things that a lot of people found most upsetting about that language was because anybody that knows anything about the history of the country, when you hear the term sovereign, it just was a reminder of people like John C. Calhoun or James Eastland saying the sovereign state of South Carolina or the sovereign state of Mississippi, as if it was sort of more important than the United States in toto.
Mm-hmm. Well, in his rationale, I should remind everyone, got Anthony Kennedy 100%. Now, in other cases we'll be talking about today, Anthony Kennedy peeled off, and in fact, he peeled off in another really important voting rights case, a very important race case, not voting rights case, and that was Parents Involved versus Seattle Schools, where John Roberts writes a plurality opinion that's that reinterprets Brown v. Board of Education, and in that one, Justice Kennedy, a centrist conservative, says, you've gone too far. This is not what Brown stood for. But with this one, Anthony Kennedy was on board. And again, I think the reason I was reminded of that is your reference to the state's authority.
Yeah, and in the Seattle school case, where this was a program that had been designed by parents there, not something that had just been imposed from the outside, Justice Breyer's dissent in that case seemed to parallel Roberts' letter to Friendly about things changing fast. He says, never have so few people changed so much so fast.
Right, and that one, there were a couple things that the liberals challenged the majority on in this case. This was in 2007, involving school integration plans from Seattle and from Louisville. The rationale that John Roberts used was quite controversial, but also that there was his premise of attacking what a school district itself was trying to do. This was not being imposed by the federal government. This was a school district actually trying to solve its own problems. And that was something he, in an earlier era, had said he was in favor of, school districts having their own control here.
So Roberts' external persona, clear thinking, rational, reasonable, but clearly on the issue of race, he has really drawn the ire of at least one of his colleagues, maybe two, but particularly Justice Sotomayor. And it seems that part of their backgrounds and the way that they grew up and what their assumptions are about the way the world operates seems to have very much affected the way they look at issues of race.
It is. Her background is foreground. She's very aware of, obviously, what she went through to climb herself out of the Bronx projects and what other people go through. And one case you might be referring to is this Schuette case from 2014 from Michigan, and it involved a provision in the state constitution that voters had approved that said you couldn't have any racial classifications in higher education. And the majority upholds that. And she writes a very stinging dissent trying to remind her colleagues about the need for racial affirmative action on campus. And she talks about someone of color feeling the sting, the slights, the feeling that you don't belong here. And it's a very impassioned, personal dissent. And he gets really angry at that. And he takes an unusual step. Not only does he sign the majority opinion, which of course is usual and predictable, but he writes a separate concurrence alone, signed alone. Let me see. I think he signed it. I'm trying to remember. Justice Scalia's in the back of my mind, but I think it's just because Justice Scalia also wrote separately. But I think John Roberts signs this by himself, and he essentially rebukes her for airing not just her personal views, but sort of some of the behind-the-scenes tensions. And both of them have a kind of how dare you tone back and forth.
Right. So, as a liberals critical of him on race, the decision of Roberts, though, that probably drew the most scrutiny and review, and the one that angered people on the right, was his decision that upheld President Obama's signature legislative achievement, known as the Affordable Care Act, commonly known as, by some people, as Obamacare. And I think one of the most fascinating parts of your book is your analysis and description and revelations about the back and forth. So why don't you unspool that for us?
Okay, well, I'll go back to 2012. It's an election year. The Supreme Court is tightly divided. 5 conservatives, 4 liberals, and everybody's wondering, what will this court do with President Obama's signature domestic achievement here? And it had 2 planks to it, 2 key planks. One that everybody talked about, which was the individual mandate that everyone needs to buy insurance by a certain date to keep the whole system afloat. And that healthy people should buy insurance, and you shouldn't get it just when you're sick. And the other was expansion of Medicaid that would help people near the poverty line. And when the justices first voted in their private conference on this, they voted to strike down the individual mandate. It was 5-4 with the conservatives controlling, but they voted to uphold the Medicaid expansion. And John Roberts had been with the majority there to uphold it. And through all these maneuvers behind the scenes over the next weeks, he switches votes on both. And he switches votes because he decides, for a couple different reasons that I speculate on in the book, that he does not want the whole law to go down. And he then finds the taxing rationale, which many of you are familiar with because that's what the court ended up hanging it on. But the justices had never voted in private on whether the taxing rationale in terms of Congress's power would support that. And then he also changes his mind on the Medicaid expansion. And instead of working with Anthony Kennedy, who'd been such a key decider on just about everything else, he wins support from 2 liberal justices, Elena Kagan and Stephen Breyer.
And
they switched their votes then on Medicaid to have a greater majority to strike that provision down.
So pre-existing conditions saved, but expansion of Medicaid for poor people. And there are more challenges looming now. Talk a little bit about that.
In fact, we just found out that, we have a challenge right now to the Affordable Care Act, and the Trump administration, as many of you know, is now arguing that the whole thing should be struck down as unconstitutional. The U.S. Court of Appeals for the Fifth Circuit is going to hold an argument on this sometime in July, and this is marching its way to the Supreme Court. And everybody's wondering, will John Roberts try to save health care again? Because here we have an even more polarized 5-4 court. And I think that could come up in another election year, because it could be 2020 easily when that comes. And I think he was very self-conscious about how he was going to rule then, and now that everybody knows what he did last time. I should say, Henry, since you were a reporter, you'll appreciate this, and there are a couple other people who've done some writing in this room. I have to say that when I was covering this in 2012 for Reuters at the time, I actually predicted that John Roberts would vote to uphold the individual mandate. So when the ruling came in 2012 and everyone was like, oh my gosh, look at how he voted, I said, oh, well, we knew that. I thought he was going to go that way. But to tell you the truth, I was wrong, because he originally didn't go that way. He had flipped his vote behind the scenes, right.
So speaking about writing and reporting, tell the audience, what's it like to interview the Chief Justice? What was the process like?
Well, actually, my points of reference involve UCI a lot, because I sent him a note, just to remind everyone, when I was here on that visiting professorship, I started in August of 2016 and it ended in August of 2017. So in May of 2016, when I signed the contract to write this book, I sent him a note saying, I'm going to write this book. I'll be talking to many people. I never say outright that I want to come see you right away, because I think, that's way too challenging. Let's just wait until they do. And they do. They inevitably do talk. I like to refer to what Justice Scalia always said, I'll never talk to you, I'll never talk to you. And he ended up speaking to me for 12 recorded on the record interviews. So, people come around. So here I am, I'm teaching here, and he doesn't respond. He's he says, he sends word that he's not going to cooperate. And I'm like, fine. This is, a 3-year project. I have time. And I can move on to other things. And there were plenty of other things. As I said, I went to Johnstown, Pennsylvania, where his parents were from. I went to northern Indiana. I've interviewed other justices. I was moving along. And I get a call while I'm here at UCI from the court saying that John Roberts wants to see me. Well, by now I'm caught up in the semester, but I figure the chief wants to see you, you fly back. And I coordinated with an argument I wanted to see. So I go back, and I could tell Henry that each time, he kept calling me back and calling me back. So you just don't wander into the Supreme Court the way you can wander into the law school here. You have to get permission. You have to get a pass to go up to the chambers. You have to get escorted. Nothing happens accidentally. And my feeling was that he was trying to get as much information from me as I was trying to get from him. And I have kidded that I would write at the top of my notepad, remember, you want information from him, you don't want to tell him things, because I'm certain that he was curious which of his colleagues were speaking to me, what was I finding out. And I frankly wanted to tell him much of what I was finding out because I wanted him to respond, but I certainly did not want to tell him about anything that I hadn't gotten on the record with certain justices. And even some of the on the record things that I picked up, I didn't want to say, and so-and-so says this. I just didn't, I didn't feel like that would be helpful. But I approached this in a very serious mode. And, I've been interviewing people for, more than 30 years as part of my professional life. And I prepared for these interviews more than I have for anything else. And I frankly left my personality at the door. I was very serious. I decided that I didn't want to be in a kind of overly warm, come on, you can, because I thought that I would do that. I was always sort of trying to, here I was dealing with a man who had argued 39 times before the court, was known for his persuasive ability, and some of my reporting colleagues had warned me about being co-opted, and I really wanted to send the signal, this is a very serious project here. I need to know as much as you are willing to reveal about what your life was like when you were young and how far you'll go in terms of answering at least some of the complaints I'm hearing from both sides of the ideological spectrum at the court. So I felt like I was getting many faces of John Roberts over the turned out to be years, over the years, and many different themes. And in the end, I believe he believed he was far more cooperative than he set out to be. But it was always a negotiation. Can I use this on the record? What can I use? What can I not use? And when you've had a lot of cooperation from past subjects, it's discouraging, because I think it's fair. I think it's fair on both sides. And I also think, and I've said this, and you probably have felt this, if you're a reporter and somebody's telling you something off the record, you're very vulnerable to spin, and you can't check it out.
Right. So, of the 4 justices have you written about, was he the most challenging as a subject?
Most difficult start to finish, and then some. Yes. Yeah.
And why do you think that is?
I think it's his nature. I think it's definitely his nature. I had done a project for Reuters that some of the lawyers in this room know about called Echo Chamber, where I worked with 2 other colleagues to look at the Supreme Court bar and who gets their petitions accepted, who's most effective arguing before the Supreme Court, who's most effective getting cases granted by the Supreme Court because it's such a hard process. And all 8 associate justices spoke to me on the record about that, for that project. And it was a project that John Roberts knew so much about firsthand because he had argued 39 times before the Supreme Court. He had been involved in doing this. And he would not, he met with me on it, and he frankly gave me insights that became very crucial for that. But he would not say a single thing for the record. So I was ready for him to be like that. Back in the olden days, I've known him since '89. I've known him for a long time. So he was once a little, before he became chief, he was a little more helpful, but he wasn't, and I'm sure he's thinking he was helpful here. Who knows what he's thinking, but.
So do you think that it's?
I think it's his nature. I think, just to, cut to he's very controlling. He's personally he's fairly reserved. I quote a man who had worked with him on the law review at Harvard, David Lebron, who's now president at Rice, who said John Roberts is an introvert who's learned to play the role of an extrovert. And I think there's some truth to that. He's personally reserved. He's not, as outgoing as, many of the familiar faces we see here, but he also is incredibly controlling. And just as he was so aware of how things were being portrayed in the media when he worked for Ronald Reagan, he's so sensitive to how the Supreme Court is portrayed now.
So speaking about the notion of how the Supreme Court's portrayed, one of the things that you talk about in the book, and I think that the commentators have talked about, is you describe a tension within Roberts, or the perception of a tension in Roberts. And on the one hand, that you have Roberts has, I think, a pretty well-established record of a conservative philosophy, a conservative ideology, whatever term you want to use. That's on the one hand. On the other hand is his perception to have the Supreme Court viewed favorably by people in the country, that that he would like people to think about this Supreme Court as if it was a wonderful institution, as if people might have thought about it years ago when run by, say, Chief Justice, the very first, Justice Marshall or something like that, as opposed to how people thought about the Supreme Court, at least historically, when Justice Taney wrote the Dred Scott decision. Right. So this is described as a tension, but when you read the entirety, or I'll just say, I'll put my cards on the table. When I read the entirety of this 349 pages and the copious footnotes and so on and so forth, that it seems like that the first tendency, his sort of overall philosophy, is the dominant thing, and that it prevails over his notion of institutionalism. Feel free to take me on.
Well, first of all, John Roberts has deep conservative roots. Right? There's no getting beyond that we've already talked about his very fixed views on racial remedies such as affirmative action. He used his first dissent from the bench in the Obergefell same-sex marriage case, where he said this has nothing to do with the Constitution. These 5 lawyers, his colleagues, had suddenly declared something, and he says, just who do we think we are doing this? So he has made clear his conservatism. But he has also, from day one, made clear this kind of self-conscious concern for the legacy of the Supreme Court and his own legacy. He has even said, you don't know whether you're going to be regarded as John Marshall or as Roger Taney, and you probably won't be the first, but you certainly don't want to be the last as Chief Justice Taney. And even before he rebuked President Trump in November, when he said there's no such thing as an Obama judge or a Trump judge, he had been saying similar things to public audiences before then, saying the one thing everyone should remember about the Supreme Court is that we're different. The Supreme Court is different from the elected branches. We're here for life. If you don't like it, there's really not much you can do about what our rulings. And he's constantly tried to separate the court. So he has a lot at stake institutionally. The court is called the Roberts Court. He does not want to see its reputation diminished on his watch. So that's why I think what's happening now is just a few little signs of him inching to the left on some of the orders and more modest rulings that don't make a lot of difference in the world. I think he'll inch to the left on things that aren't very costly for him, on things that might be more costly, maybe pace things out. Right now, they've been sitting on, for months, disputes over whether Title VII of the 1964 Civil Rights Act, whether its job protections covers people based on sexual orientation or gender identity, the way it covers, based on nationality, sex, and race. So I think he's trying to avoid issues so that with these 5 very strong conservatives, the court doesn't appear to be following the dictates of Donald Trump.
Okay. So before we open it up for questions, I want to ask you about one more hot topic. Whenever a Supreme Court, somebody gets nominated to the court now, there's a lot of discussion about Roe versus Wade. Will Roe versus Wade, how are you going to vote on Roe versus Wade? In reality, people who are anti-abortion choice don't have to overturn Roe versus Wade. Abortion can be killed by 1,000 cuts, the right to abortion. And a few years ago, we had a case coming out of Texas where basically they were going to make it very difficult for people to have abortions. The court spurned that whole women's health case, saying that it would create an undue burden. But it looks like there's a lot more of these things. So where do you see that issue going over the next few years?
Well, let me just make a point about that. The case that you just referred to, the 2016? Yeah, 2016 case where Anthony Kennedy was the swing vote to strike down the restrictions in Texas. And, he's gone now. So I see only more restrictions. Certainly states across the South and in other Republican-led jurisdictions are trying to impose more regulations. So the court will be tested. This is another set of cases where the justices have let things, they're not acting. They're not acting on some of these laws that are coming up on it. The chief seems to want to pull back. And in fact, in early February, in a case involving a law from Louisiana that was similar to the Texas one, he actually voted in a way that ensured that that law did not take effect. And people made a lot of that ruling, but it wasn't a ruling. I want to clarify that it wasn't a ruling, it was just an order. So we don't know where he's at on the merits. And some of my colleagues think that we're going to get a 5-4 ruling straight up against Roe v. Wade. I'm not with them. I just don't see John Roberts wanting that for this court. But I agree that there are many other ways to seriously restrict the right to abortion.
Okay. Well, I think it's time to take some of your questions. Floor is open. Question. Yes, sir.
It sounded as if some of the justices would speak to you off the record. And if they do, what do you do? How do you use that information?
What happens is you find out something from one justice or an officer of the court or a law clerk at the court. You get information and you want to find out if it's accurate. Because if somebody tells me something that happened on the inside, I can't just believe that person. I have to, especially since I actually don't use law clerks a lot because I find them to be what I refer to as very chamber-centric. They really like their justice and they see things through that justice's eyes. So I can't just, if something is given to me as inside information, I just can't take it as is. So I will use these subsequent conversations with justices to test what I've been given. And you constantly have to weigh, what do people know, what do people not know, and memories are flawed along the way, and people have their own motives. Even if somebody's trying to give you information, they might not be giving you the whole story. So you use all these conversations to try to get a sense of what's real and what's not. And the best way to get a sense of what really happened is with documentation. And over the years, I've used a lot of justices' papers, starting with the Lewis Powell files for Justice O'Connor. She was a dear friend of Lewis Powell, so I found I could understand her through his files. We understood what was going on with the court in the 1980s through the files of Thurgood Marshall and Harry Blackmun and William Brennan. But there are no papers right now. There are no papers for this the contemporary court. And in fact, I just wonder if we'll ever see papers. Probably not in my lifetime, that's for sure. So if you don't have documentation, which is the surest way that you can know something or hope you know something, although I do have to take a little detour to say one clerk said to me, "Oh no, the really good stuff doesn't go on paper." So, but anyway, it's always a challenge. So and you go back to people. I went back to justices a couple different times to say, I heard this and then I heard that, and when I was trying to unravel the Affordable Care Act story, a lot of it, or half of it, I knew in 2012 from interviewing justices at that time. And I should say that Jan Crawford of CBS had a story right after the ruling about the anger behind the scenes over part of Roberts' flip vote on one part of it. And nobody had ever been able to duplicate that reporting, but I had at the time justices had filled me in on that, but it was not, there was no reason for me to write about it, really. But I went back to a lot of those notes, and then again, trying to recreate it. So that's how you used information that might be off the record. And then is that you kind of figure out, okay, even though I can't say that this person's telling me this, it can either affirm or undercut. And there were many things that I was told by law clerks who had worked for John Roberts off the record that just did not jive with what I was getting in other ways, that just, I didn't think they didn't serve the chief. They might have served the law clerk. They might, so I always had to be very careful. And the way you solve it is to keep going back to a person and others. Thank you.
Yes, over here.
With your tremendous background with the court, are you able to comment on the current political situation in which the dialogue is, we don't like the way the election goes or it changes, to expand the court so that the political party may stack the court?
You're talking,
It scares the hell out of
well,
me.
and I actually am one person, you hate to say in this day and age that, oh, that'll never happen. But this one, I think I can say, it was 150 years ago that Congress set the 9-member court. And, it's in Congress's power. So you don't need a constitutional amendment for it. Congress could do it. But there have been attempts over the years, and they've failed. And I think the chief worries about that. The chief thinks, he worries about certainly the criticism from the right wing and from people like Donald Trump, but I think he also worries about proposals like that. I think it's born of this moment. It's certainly born of the moment of Senate Majority Leader Mitch McConnell not giving Merrick Garland any kind of vote in 2016. It's born of the dissatisfaction of Donald Trump getting 2 appointments and everyone living in fear of what's going to happen to our 2 justices who are over 80, Ruth Bader Ginsburg and Stephen Breyer. But first of all, you'd have to have, how many pieces would have to align to get that? First of all, you'd have to have the Democrats win back the presidency, then the Democrats win back the Congress, both chambers, and then be able to pass this. And if they get that far, they might think, we can just replace somebody on the Supreme Court rather than court pack. So, but you learn. I go all the way back to the Bill Clinton times when I used to say, he'll never be impeached. Well, sure enough, he was impeached. He wasn't convicted. And then, you get used to, and I remember being here in November of 2016 thinking, wow, look what just happened. So but I would say I still feel pretty confident that court packing is not in our future.
60-40?
Yeah, yes, I'll get, yeah, right. I'll give it at least that, yeah. Thank you.
Any over? Oh, yes, Michelle?
So, and thank you so much for being here, Joan. We had such great times when you were here, so thank you. I'm wondering, with regard to the Chief Justice's presentments on race, whether your sense is that his early presentments in his early 20s were rooted out of naivete, growing up in Indiana, although that was the birthplace of the Klan, but this sort of sense of not knowing, in a way, let's say, had he grown up in Mississippi or Texas to be aware of what race is really like? Or do you think that it actually comes from a different kind of space? And here, of course, it's very important given the implications of his decision with regard to voting rights, with regard to education, and so forth. So where do you think that rootedness is in terms of his perspective?
I think it's a combination. That has been, that was an important question for me. An important question, and I will say at least that I raised it in talking to him. I can't say what he's told me, but I raised it because I think it's an important question. He's not the only conservative who believes that, certainly, that racial remedies are not a good thing, that they've done more harm than good. I can say with confidence, he's probably, I shouldn't use the word probably. I can say with confidence he's never been excluded from a job because he was on the negative end of any kind of preference for somebody else or anything that was where there would have been an emphasis to try to bring in more diversity. So he doesn't have that going on. His world has been mainly people who were quite like him, both at La Lumiere and at Harvard. I don't know how much he did see the larger context. And I often will, this comes up a lot when I talk about the difference between him and Sonia Sotomayor and all that she experienced. a speech that he gave in 2013 to the graduates of this elite prep school, La Lumiere. He emphasized that persistence can solve anything. He said, you can be born with good looks, great family, wonderful location, superior education, everything going for you, but what really matters in life is persistence. And he said, with persistence, you can overcome everything. And I think he really believes that. I think, first of all, he is a persistent individual. He's been very focused, but he came with the package, and Sonia Sotomayor sits back and think, hey, I might have been persistent, but a lot of people start with a much weaker hand, whether it be in terms of race, religion, sex, where they come from, poverty, the whole thing. And there's no way sheer persistence is going to bring them up. But I think it's a view that's born of his background and the world his world has been reinforced at various stages of his life.
I think we can take one or two more. Back there.
Yeah, I was wondering, you used the word to describe him as controlled. As I was reading through the book, the word that came to my mind was calculated. But I know that has kind of a negative connotation. I wondered if that's a fair assessment.
I think it is. I think he is. I've used, I had to do a word search on myself as I was writing because there were so many times I would refer to strategic, tactical, calculating. But he is. And you're right. Things can have a negative connotation or not. I mean, he wants certain rulings. He wants his vote to prevail. He wants to be in the majority. He wants to convince his colleagues. So yes, he's always looking ahead. He's always trying to figure out, will this step lead to the next step, lead to the next step? And as I was doing the earlier books, when I was doing research on Justice Scalia and then Justice Sotomayor, that calculating theme was coming up. And it didn't matter to me that, for those books, I didn't need to talk about the chief's manner all that much. I did, in the Sotomayor one, talk about the clash between the chief and Justice Sotomayor on that Chudy case that I referred to earlier. But I didn't really need to detail the distrust that had been percolating among the colleagues. And part of it is because they do see him as being calculating. The positive version is, careful, more careful, wary, reserved. But I think some of his colleagues believe it's toward an end that does not necessarily serve them.
Yes, I'm sorry, I haven't read the book yet, but I will. Have you gotten any blowback or feedback or comments from anyone on the court, be it the justices or the clerks or staff or anyone?
I have heard from, yeah.
Or you did a good job?
I've heard from, I usually, there have been times in my life when people didn't like things and they made sure I knew. I haven't heard that yet. I haven't gotten it. I'm just going to talk about the associates right now. I actually have, since it was out, I have met with 2 of them and I have heard from 3. And that's, hey, it's a majority as far as I'm concerned. But, but I have also said that every time I do one of these books, or the big project like that echo chamber I was referring to when I interviewed them all and things, people, colleagues have always said, they'll never talk to you again. They'll never talk to you again. And, it's one thing to talk to me and to say, oh, I'm going to tell you what's going on. And they do. And then it's another thing when they see it in their print and they're like, that's all right. I did tell her that. And so I expect that some of them might be thinking, gee, I wonder if I should have told her all about that. And there are only 9 of them. There are only 9 sitting justices. Now, we do have, 2 who are retired and 1 who's passed away, who, I was in communication with them through the years too. But I got a wonderful call from a justice last week, and this justice didn't preface it by saying this is off the record, as some others do right away, but I still don't want to give the name. And it was a great call because it was completely unsolicited and it was completely affirming, and it was just like, this is how I see the court. This is an accurate portrayal, and I just want to make sure any of you in the room and those watching, this person was not speaking for the whole group, okay? So I'm not presuming that is being felt unanimously. I don't think I would get let me just put it this way. I don't think I get a unanimous ruling on anything in this book because they all have different interests. In fact, somebody who's very close to one of the conservative justices who's had a lot of tension with the chief has said, do you think that in some ways they'll be happy that you've written about some of their feelings toward him? I'm like, no, nobody's ever really happy. but I've been, as Henry knows, I've been so happy that the reviewers have really felt, for whatever they find, pro or con, that it is even-handed, and that I've been thorough, and that I tried, what I said to the chief, and I can tell you what I said to the chief, and I can tell you what the chief said to me, but I said, I took no cheap shots in this book. There's so many different issues that other reporting colleagues might have gone after in this book that it wasn't my style of reporting. I was sticking to what went on mainly in the Marble Palace, as it's called, not what went on in his personal life.
Take one more, Leah.
My question was going to be about like the personality aspect as well. So like he has this like very cold, calculating, contrived personality that was like, well, I'll use words, you don't have to. Evident for the Reagan years when he's like massaging the words and messaging, and like you also see that on the court, you mentioned Shelby County and some other examples. But he doesn't seem capable of doing that vis-a-vis his colleagues who seem to have figured it out and like gotten his number. Like, is this just like a personal failing on his part, or like why can't he keep it together with them? Why can't he be the John Roberts we saw in the televised hearing?
That's an interesting question, because one of the justices said to me at one point about that whole personality thing, because I was picking up so much of some of, for lack of a better word, snarky comments that he would make in conference to his colleagues. And one of the justices said, you'd think he'd be able to hold it together for just the hour or so of the conference. And I thought, and I don't, again, these are exceptions. I presume that mainly it's okay. Seriously, I don't want to portray the place as kind of always, a hotbed of unhappiness, because it's not. It's like the rulings. They have a bunch of unanimous rulings, and then they have these 5-4 ones. But I think that I don't think he is aware, or if he's aware of how he's perceived, he has not been able to change it that much. And one thing Antonin Scalia did say to me that I thought was so revealing, that I didn't use in the book I wrote about Justice Scalia, but then I did use in this one. It was back during one of my early interviews with Justice Scalia, and he was talking about the difference between Bill Rehnquist and John Roberts. And he said, Bill Rehnquist had enough time with the other justices, 14 years as an associate justice. He knew how to work with him. He used the phrase, his hide was toughened. He wasn't as self-conscious as the new John Roberts was. And I think John Roberts just early on, and it's continued to be a bumpy ride in terms of working with his colleagues. But you're right. He projects, though. People are so astonished. When I first started this project and people would say, is the standout really a stand-up guy? I'd say, well, some of his colleagues don't think so.
Just like to thank Joan for coming and say to everybody here, buy the book.